morning, everyone. I can get my chair in here. Oh, Lord.
We got the same problem.
We got this rigged against us. Welcome to the First District Court of Appeals. We have 3 cases up for argument today. I will read the case, and if you could please, the attorneys could please state their names and their readiness to proceed. The first case for argument is State of Ohio versus Reed. That is C-240530.
Good morning, Your Honor. Sarah Nelson on behalf of Mr. Reed, ready to proceed?
Nora Wessels on behalf of the state of Ohio, we're ready to proceed.
All right, great. And we have 2 other cases that were, they were tried together below, appealed separately, but the parties are going to argue them together. We have Ravenscraft versus Durrani, which is C-240297, and we have Bowling versus Durrani, that's C-240298.
Phil Williamson on behalf of Dr. Durrani and Cast, ready to proceed.
Okay,
Alan Chapman on behalf of both.
great, thank you.
Ben Moran also, he had to step out.
I saw him in the hallway. Okay, so we're going to go ahead and get started with the Reed case. Ms. Nelson, would you like some rebuttal time?
Yes, 2 minutes for rebuttal, please.
How many? 3, okay. Whenever you're ready.
Thank you. Good morning again, Your Honors. May it please the court. Good morning, opposing counsel. Sarah Nelson again on behalf of Mr. Reed. This case concerns an as-applied challenge to Ohio's requirement that a person must be 21 years or older in order to carry a concealed weapon. Mr. Reed was 19 years old at the time he was found to be in a possession of a concealed firearm, and the age restriction under the CCW law is the only thing that had prohibited him from having a weapon in this manner. It's our position this morning that the statute is unconstitutional as applied to Mr. Reed because he's an adult with no criminal history, and there are 3 points that I would like to make in support of that position. First, under this court's precedent in Storms and Barber, I believe it's settled that the Second Amendment does cover the concealed carry laws. That was a question that came up in this court when I've argued this issue previously, is whether or not the right to bear arms is burdened under the Second Amendment. Whether the Second Amendment burdens, Ohio's concealed carry laws burden the Second Amendment when a person also has the right to open carry, which Mr. Reed does. But this court's precedent seems to suggest now that it doesn't matter. As long as the right is being infringed in some way, like the CCW laws do, then it covers, we're in Second Amendment territory. The first step of
The
satisfied.
state has conceded this, right?
So there is some discussion in the state's brief that the Second Amendment doesn't apply to persons under the age of 21 because at common law, they weren't adults. So to get over that discussion, I skipped straight to talking briefly about
Okay.
this. But they do go through the historical analysis, and they definitely don't outwardly concede this
They
point.
seem to be concentrating on the second.
Yes, that's correct.
Okay.
So if there's no confusion on the first prong of Bruin,
So just to clarify, when we're looking at step 1, we only look at the conduct. We don't look at alternate avenues. We don't look at anything other than the conduct itself to determine whether it is covered by the Second Amendment. Is that correct?
whether the plain text of the Second Amendment covers the conduct at issue, yes.
Okay, thank you.
Yep. So the second point I wanted to bring up is that, in our view, there is no similar law or source in the vein of concealed carry that is consistent with our nation's history and tradition of firearms regulations. Age isn't a factor in terms of firearm regulation at the time of our nation's founding. The first time we start seeing age sort of get introduced in the realm of concealed carry isn't until the Civil War era.
But let me ask you this, though. We do have a history and tradition of prohibiting concealed carry, right?
Across the board, for all
Correct.
persons.
Okay.
So now what we're talking about is a category-specific restriction. And
Okay.
age has never been part of the purview at the time of our founding.
Okay, but, you know, when we're talking about this category specific, and I think I asked you this question previously, why wouldn't that be more of an equal protection challenge rather than a Second Amendment challenge?
Well, so it's outside of the purview of equal protection because it's conduct that is regulated by the Second Amendment. So until the United States Supreme Court tells us that this is a specific type of restriction that gets equal protection treatment and outside the purview of the Second Amendment, it's still squarely before the court under Bruin.
But your client's Second Amendment rights haven't been completely taken away. That's where I get hung up, right? Your client can open carry?
Yes,
Okay.
but this court has said that his right has still been burdened. So we continue to.
His right what?
Has still been burdened.
Okay.
Heller says that it's not just about open carrying, it's carrying a weapon however you choose, whether
But
that's
our
in your
history and
pocket.
tradition, you said, has allowed the state to completely prohibit concealed carry across the board. So that burden, that in your view, burdens the Second Amendment. Right?
Well, when this court addressed that issue talked about that issue in the Barber case, it then pivoted to individual restrictions. It said that we still have to analyze these individual restrictions.
I understand that, but I'm just trying to understand when we talk about burdening the Second Amendment, would you agree that you just said that our history and tradition supported carrying concealed restrictions across the board? Would you say that that burdens the Second Amendment?
I mean,
If you can
yes, it
open
does.
carry, if
Yeah,
you can
yeah.
open carry.
I understand what you're saying. Well, I think I think it does, but I think Bruin also says if you're completely restricting concealed carry, we're not going to say that those laws are problematic as long as the ability to open carry still exists. But where we're at here is that concealed carry isn't across the board.
So do you think it would be constitutional if it were across the board? If Ohio prohibited concealed carry for everyone but allowed open carry, would that be constitutional?
I would say yes, I believe under Bruin.
Okay.
But that's not the issue before the court today, even though we're dealing with a category of people that across the board get.
The legislature has instead selected certain people to say that, okay, you all can open carry, but you can't conceal carry.
Yes.
That's your problem.
Yes.
You're saying that if they're going to do it, everyone should be not permitted to conceal carry, then it's okay.
Or there has to be historical tradition support for the specific
For
carve-out.
that specific group of people.
Right, just
Okay.
like we analyze felons in possession, persons with mental health concerns, things like that. We go through the individual restrictions and we question, are these supported by our nation's history and tradition? And age gets the same exact treatment that all the other restrictions have been receiving.
So, Ms. Nelson, I know that the state cited historical traditions and historical laws that made the age of majority 21 for particular activities. And so are we to look at the number, age 21, or are we to look at the age of majority for purposes of this law
So-
and this restriction?
In my view, we take the modern day context. What is an adult? An adult is a person over the age of 18 or older, right? And then we look back, what does the law say at common law in our nation's founding about adults? Now, when the age is different, at least one court has said, well, age was different across the board for a lot of things. So without tying age to the right at issue, it's sort of a red herring to say, well, the age of majority was 21 back then, it's 18 now. We can restrict people who are 18 now because we restricted people from doing a lot of things when they were younger than 21 back then. But there was nothing specific about firearm regulation, which is where the state's analogy fails.
Can you go into that a little bit more? I mean, I know that there were at least some statutes that required young men to have weapons.
Yes, the ones from the founding, or at least were enacted around the founding, were the militia laws. Now, some courts will say that we can't look at militia laws as persuasive authority on what the founders believed at the time, but at least one court has said it's at least circumstantial evidence that persons within this certain age group were in possession of firearms, and they found that that was persuasive. Which kind of cuts against the state's argument. Well, we were allowed to regulate people, but we were also allowed to provide them the ability to have firearms, which is what the militia law did. It gives us this context that people of the age 18 were in possession of firearms.
So outside of militia, though, at the founding, at the enactment of the Second Amendment and the 14th, were 18 to 21-year-olds permitted to carry weapons?
I believe so. I believe the laws at the time really only restricted certain time and place of use, but there were no age-specific restrictions at the founding. I believe those age restrictions weren't introduced until the Civil War era. And one court says, well, okay, we're allowed to look at both time periods because the 14th Amendment ratification is relevant, but when you have no counterpart at the time of the founding, there's no historical tradition to bridge the gap between the two. So the lack of historical tradition from the founding is important in this case as to why the age restriction isn't supported by history and tradition.
Counsel, doesn't that history and tradition overall deal with only allowing people who can safely carry firearms to do so? So people with mental health issues can't do it. People who have a criminal background can't carry. And what we've determined is that people who lack a certain maturity also can't safely carry firearms. So isn't that consistent with the tradition of isolating people who can't safely carry firearms broadly? That makes sense?
Well, this is an as-applied challenge, so I'm not going to get into all adults between the ages of 18 to 20. But what I will say is that even when this court has been confronted with certain categories of people and whether or not they fit into the category of dangerousness, which is an idea that the United States Supreme Court introduced in Rahimi, we can still find the law unconstitutional as applied to a certain person if they don't fit necessarily the felon background. We can disarm felons, but if this particular felon isn't dangerous, then the law is unconstitutional as applied to them, which is Mr. Reed's situation. He has no criminal history. The first contact he's ever had with law enforcement was this case, and the only reason why police were able to arrest him was because of his possession of firearms based on the concealed carry law. So in our position, he doesn't meet this traditional mold of somebody with lack of maturity because he's shown that up until the age of 19, he has had no run-ins with the law. He's a law-abiding adult at the age of 19, able to go about without engaging in any criminal activity. At the time he was stopped, he wasn't even under arrest for a specific crime. He was with a group of people who collectively were being suspected of trespassing. But just because police are allowed to approach you under suspicion doesn't mean you're actually engaged in a criminal act. So because Mr. Reed lacks any sort of traditional notion of dangerousness and because the laws don't support, at the time of our founding, restricting concealed carry for 18-year-olds, 18 to 20-year-olds, we'd ask this court to find the law was unconstitutional as applied to my client.
And you're relying on Barber for this argument?
For the
For the dangerousness argument, the dangerousness analysis for a situation where the person is not prohibited from carrying full stop. I mean, your client can carry a firearm.
Yes, I think Barber is-
Openly.
Yeah, Barber
So
definitely.
Thacker was a full prohibition of against carrying a firearm at all, right?
Right,
And this
because-
case is very different. This is a situation where your client can have a firearm, he just can't conceal the firearm.
Correct, it's definitely more analogous to Barber. Thacker was introduced, that idea was discussed in Barber, so I'm bringing up that case, obviously, but it's definitely more aligned with the decision in Barber.
Okay.
Do you mind if I know our time's up, do you mind? Okay. So in March, the 11th Circuit released NRA versus Bondi, which dealt with this issue, at least the 18 to 21 issue, but in that case, it was purchasing a firearm.
Okay.
And found that the Florida law was constitutional. I don't know if you've read that, but, and then there was at least one case, and the name is escaping me, that found that the restrictions are unconstitutional for 18 to 21-year-olds. So this will most likely be taken up by the Supreme Court sometime soon. Do any of the, I mean, how are we to look at these cases in deciding this case?
So I'm not familiar with the Sale case as much as I'm familiar with Lara and Worth, which were both cases, I think, that the United States Supreme Court declined cert over, which I think is instructive with respect to the historical analysis that they provide in those cases. I'm not sure if the Florida case is inconsistent on the historical observation, and I'm not necessarily sure of the nuances as it relates to sale. But I question if a person can still possess a firearm even though they're not allowed to purchase one. That would be one question I have about that case.
I don't remember.
Right. So there's some nuances in the law that I've seen in some of the sale cases that I've read, that they are very clear. We're not talking about their possession. We are only talking about whether or not this firearms dealer can make this sale, which is a completely different arena than whether or not somebody can just have a firearm if it's lawfully purchased by somebody, if the firearm is gifted to them by family. I will say that I think some of the historical sources on that point did allow for persons under the age of 21 to have firearms if it was provided by somebody who was able to lawfully purchase it. So to the extent that we're talking about history and whether or not somebody under the age of 21 could at the time have a firearm, the answer I think is squarely yes.
Thank you.
Thank you.
Thank you. Mr. Wessels?
Thank you. May it please the court, opposing counsel. I'd like to address the question that you just asked, Judge Bach, because I think it maybe provides us a little bit of framing about this court's particular challenge with this case. Some of the cases that I believe the court is referencing make reference to what I would describe as firearm regulations that are, I think, more, maybe not severe is the word, but they generally regulate more than what's at issue here, which in this case, I think it's been conceded, we're only dealing with whether or not the state can regulate someone's ability to carry a concealed firearm on their person based upon their age. And this court has already said in Barber that the evidence that we've provided has, quote, established a historical tradition of restricting the carrying of concealed weapons. So I do believe that, at least for the purposes of whether or not the state can restrict concealed carry, I do believe that this court has already accepted that the historic evidence presented by the state is convincing in that aspect. This court has also said that open carry is, quote, relevant to determining whether the burden imposed is a comparable burden to historical analogs. And I think that's maybe the difference that we get in here when we're discussing maybe the difference between Barber and this case. In Barber, the state's justification was focused on a dangerous determination, and that's where this court went back to Thacker in deciding, whether or not the justification, the why of that justification made sense compared to those historical analogs. I think where this case differs is I don't necessarily believe that this is merely a dangerousness determination when our historical record that we've presented, I think, establishes that, as Judge Moore, as you pointed out, that English common law and in 18th century American law, that infants were universally believed to lack the rationality, and because they were viewed as requiring the protection of a guardian in the total management of their affairs, the exercising of their rights was necessarily something that the state was permitted to regulate around. I share opposing counsel's maybe frustration, and perhaps it's the frustration of this court. This does seem like an equal protection clause, and perhaps would be more easily established under equal protection. But even analyzing constitutional law on firearm regulations under equal protection requires some analysis of Second Amendment. So until the U.S. or maybe the Ohio Supreme Court gives us some recognition on what we're supposed to do for equal protection, I believe it's maybe both of our position that the best thing to do is try and follow as close to what Bruin and Rahimi have said as possible.
But if the state is permitted, I believe you agree, and the appellant has said that it does not violate the Second Amendment for the state of Ohio to prohibit concealed carry for everybody, right?
Yes, that's the state's position.
Okay.
So
if they carve out certain groups of people, because, the why, the historical why was what?
For the regulation of concealed carry.
Yeah, why did they prohibit concealed carry and it was okay?
This court seemed to, in Barber, suggest that the only reason that concealed carry was regulated is because concealed carry, the weapons themselves were considered dangerous. I would not take, that's my reading of Barber, is that when analyzing concealed carry and those historical laws, one of the reasons that they regulated it.
You don't agree with that?
I disagree with.
What do you think the why is historically?
I believe, and I think it's difficult to, now we're talking about sussing out the public policy reasons of historical, of the founding fathers, but
Don't we have to do that?
we do.
Okay.
I'm frustrated,
Hey.
I mean, I'm.
We're stuck with
We are,
these
we are.
cases.
I think that, I don't think that it can be narrowed down to one simple reasoning for why concealed carry was regulated back at the founding. My reading of the historical analysis of Bruin is not just that, and I do think there is support for the idea that one of the reasons that they regulated is because something like a concealed dagger or like a snub-nosed pistol or something could be considered, dangerous. But I also think they had a fear and a concern around both the types of people that were carrying these things and the specific threat that these hidden weapons posed to certain individuals. That's why I think so many concealed carry laws also went hand in hand with something like transportation. The fear was that a traveler who's going around with a concealed knife or a concealed pistol could hide from other individuals. That is a specific threat that I don't think is present when you have the option for open carry.
So it's not precisely the act of carrying concealed. It's the concern of the type of people who would be carrying concealed and what they might do with that weapon.
I'm hesitant to say that it's definitively one, but my reading of Bruin and of the historical analysis is that I think that is also a consideration that the founding fathers had, which is that it's the type of people that might be concealing these. We want to make sure that if someone is carrying a concealed firearm, that they're the type of person that we allow them to do so, because the threat posed by a concealed weapon is to the public is
Right.
necessarily less than the one posed by an open carrying. That's why my opinion, and perhaps I'm hearing the same from opposing counsel, is that if the state of Ohio wanted to ban concealed carry totally, I think they would absolutely have a constitutional authority to do so. I think that absolutely matches with historical analysis. To that extent, the state's position is that if we provide some sort of lesser, if we allow for concealed carry and open carrying, we should be able to regulate that concealed carry in line with historical principles.
In line with one of the whys would be to, as a policy consideration, not allow certain people to carry concealed.
Correct. And I think, as Judge Moore, as you pointed out, one of those would be people who we can presume to lack the rationality generally associated with the exercising of not just Second Amendment rights, but any constitutional rights. We had pointed out the Weber case, which was decided before Bruin, I think in the past have described Justice DeWine's concurrence as prescient, because in it he examines specifically the first step of Heller, which is now the only step under Bruin. And one of the things he said is that it was widely accepted by the founding generation that minors who had not obtained the age of reason could not exercise their natural rights because they lacked the reason with which to do so. I think we've pointed out that minors were subject to far greater state supervision than any other legal entity involved in the marketplace during the early years of this republic. And I think in addition to that, there has been some suggestion that, for example, well, isn't it true, and I think Judge Moore, Judge Bach, you had talked about weren't juveniles permitted to carry weapons? And I think there's a distinction to be made on the principle level between merely being permitted to do something and it being considered a right for those individuals.
Well, they're still permitted. The 18 to 20-year-olds are permitted, they just can't conceal.
Correct. And I think the question is going down to, at least in the historical analysis, who's the person doing the permitting? In the sense that a guardian is under complete control of a juvenile or an infant, as to use a term of art. It's not the state that's doing that permitting. It's the parent. If the state didn't allow the parent to do that permission, they would not be. I think the distinction I made. And to that extent, when we look at militia service for those who are under the age of 21, I mean, my understanding of the analysis and the history that we've cited is I don't think militia service is a good way to pinpoint an exact right. The position of the state is that, if we're forcing an infant to do a thing, I don't believe that's the same as them exercising that right. In addition, at least from my analysis of the history, As of 1813, minors under the age of 21 required parental consent to enlist in the Army. And even before that 1813 federal law, infants under the age of 21 could be discharged against their will if it was the request of their parents to do so. In that sense, it was really, as I've described it, an infant being forced to carry a firearm at the behest of the government.
But
not
isn't the whole idea, though, that the state felt that they were responsible with firearms?
Correct, and that's my point. Well, the state felt, sorry, can you rephrase?
The history and tradition, I mean, for the appellant side, is that the state felt that these young people were in fact responsible with firearms.
I would disagree. I would think that the only, I think what we can point to is the fact that at the early ages of our country, it was the parents who were required to provide the firearms for their infants, and then those infants were required to undergo training at the behest of the state in order to properly handle them, and only handle them under the supervision of the state. To the extent that colleges or parents or even those military officers could control those infants, to me that doesn't speak to a belief that those infants were presumed to be able to control. To me, it seems as though they were under direct supervision. It's like,
Heavily regulated.
Heavily regulated with respect to, and to that extent, I think it follows along with the general tradition when it comes to minors, whether it's voting, exercise of free speech, or any other sort of exercise of right. The founding era principle that the state would point to is this idea that those who were under the age of 21 were not treated the same. They were necessarily considered to lack that rationality. Perhaps there's a little bit of dangerousness that maybe they could also be concerned, presumed in. This maybe goes back to this understanding that there could be multiple policy considerations. But certainly, to the extent that in the founding era, the state was able to treat infants, those under the age of 21, as different for the purposes of regulating a constitutional right, that is absolutely supported by the history as I see it. I don't believe I have anything further unless the court has any more specific questions. Okay, all right, thank you.
Thank you.
Thank you.
Ms. Nelson, you have 3 minutes.
Thank you. Just to pick up where he left off, my position is that, yes, there are military laws on the books that are circumstantial evidence of this specific age group having access to firearms. And the state wants this court to read that and say, well, it was a restriction. They were restricted in some certain way. But that's one way of interpreting this, and one court has said this is circumstantial evidence of actually having possession of firearms. And why they point that out is because the state can't point to any law that squarely prohibits the possession outside of that military context. So
Wait. Your client can possess
I
a
understand.
firearm.
Yes.
This is a restriction of the possession, right?
Yes, but what I'm talking about is that common law. There is no similar tradition of the age-based restriction on the books. Concealed carry, if it was prohibited across the board, I'm talking about a firearms-related restriction that touches on age, and there isn't one. So when we fast forward to the civil rights era of laws and we start introducing this idea of age, my argument is that that's not sufficient historical record because there was no such thing, common law, introducing that same type of age-based restriction. So the state, at common law, looks to this general topic of infancy, which I said in my opening remarks that doctrine was all over the board in terms of what age infants, persons under 21 could do a lot of things, get married, enter into contracts, buy property, etc. So it's not actually a persuasive point in terms of firearm regulation at common law. Regarding dangerousness, it's again unclear in terms of infancy who fell under this lack of maturity group when 16-year-olds could do certain things that the infancy doctrine says is less than 21 years old. So where are we in terms of maturity when it relates to firearms, and we have no firearm regulation at the time of common law? But one thing I wanted to point out is that even if we say collectively 18 to 20-year-olds lack a certain level of maturity, that does not apply to my client. My client was a law-abiding adult. He has no opportunity to approach the court and say, hey, I'm a law-abiding adult. Allow me to have a concealed weapon unless and until I commit some act that robs or deprives me of that opportunity to go about my life in a lawful way, like the disability laws, right? That's something that this court has acknowledged when it comes to whether or not a person can show a pattern of responsible behavior, et cetera. They can ask for relief from disability. We don't have that in the concealed carry context. So for all the reasons stated in my brief and for the court this morning, as applied to my client, we'd ask this court to find the minimum age restriction is unconstitutional.
All right. Thank you.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case is submitted and we will issue a timely decision. All right, the next cases are Ravenscraft versus Durrani and Bowling versus Durrani. And Mr. Williamson, would you like to reserve some rebuttal time?
Yes, assuming it's 15 minutes aside, I'll reserve 3.
All right. Whenever you're ready.
May it please the court, Philip Williamson, along with my co-counsel Andy McCullen, on behalf of Dr. Durrani and Cast. There are a number of ways the court can resolve this case, but I think the easiest one is through Dr. Wilkie. Dr. Wilkie was Ms. Bowling's primary expert, and he was not qualified to testify at the time of trial. On that basis alone, I think the court can vacate the judgment in her case and remand for a new trial.
What is the amendment, what's the effect of the amendment to the rule?
So, Your Honor, if the court were to vacate today, remand for a new trial, the new rule would apply to that retrial. And so plaintiffs could at least make the argument for having Dr. Wilkie testify. Now, I think for some reasons that are on the record, some that are not, it's very unlikely that Dr. Wilkie would actually testify at a retrial. So part of it is Dr. Wilkie is actually engaged in litigation against firm or former firm plaintiff's counsel related to some of his testimony in these cases and has not testified in a Durrani-related trial in some time. Frankly, based on the pleadings in that litigation, there'd probably be a challenge to Dr. Wilkie on the basis that he may be testifying on a contingency fee basis. So it's a long way of saying, it's not clear that on a retrial, Dr. Wilkie would actually testify. It's only that perhaps this Rule 601 disability would no longer apply.
Okay, so I'm also looking at Evidence Rule 1102, which says that amendments apply to all proceedings and actions brought after they take effect, and also all further proceedings and actions then pending. And there's some case law to suggest that pending includes pending on appeal. Can you talk to me about that, please?
Sure. So I think one place to begin thinking about this is what would have happened if the trial court had, for example, granted Dr. Durrani's motion before trial when he moved, or if the court had entered judgment at any point during the 2 years that passed between the trial in this case and the final appealable order. Dr. Wilkie would have been disqualified. There would have been no question about sort of the application of future amendments. And I bring that up because the delays in this case featured pretty prominently in the argument over whether Dr. Wilkie should be allowed to testify in the first place. And I would simply ask on that score, sort of what is good for the plaintiff goose be good for the defense gander as well. It creates, I think, a second problem, which is you effectively allow parties or the court to wait out their errors in hopes that the rules might change. If the case sits long enough, maybe the courts, maybe the General Assembly will pay attention and change the law to sort of cover up or to solve an error that was committed at trial, which is not the sort of thing this court has indulged in the past, and I don't think is something the court should indulge here.
So Rule 1102 does say the amendment applies to all proceedings in actions brought after they take effect, and also all further proceedings and actions then pending. But it also says, except to the extent that their application in a particular action pending when the amendments take effect would not be feasible or would work injustice, in which event the former procedure applies. So are you arguing that this would somehow work some injustice? Because the case is pending.
Case is pending.
Yeah.
So there are a couple of places where I think it would work injustice. First is that, again, you have the situation where a court effectively sat on a judgment for 2 years and allowed the law to change, sort of out from under Durrani. We made the argument we could at the time.
Is there any
Second-
indication from the record why this was sitting for so long?
No, Your Honor, this
Okay.
just
It was just sitting.
there's a motion and there
Okay.
was no movement. The second place where working injustice is something I alluded to in response to Judge Bach's question, is that actually there are additional reasons.
But those aren't on the record.
Those aren't on the record, Your Honor. That much is true, though the lawsuit by Dr. Wilkie against Eric Dieters and his former firm, is a matter of public record. It's a complaint that's been filed in Kentucky that I am more than happy to supply to the court if we would like to see it. But there would be reasons to challenge Dr. Wilkie's competence to testify on other bases. And so I think if you were to apply the rule sort of only to the information we had, a new rule applied to our old information, you work in injustice because we didn't have an opportunity with the old information, namely other reasons Wilkie was unqualified, to present to the trial court at that time. And if we'd had it, we certainly would have challenged him on more than just the Rule 601 grounds.
Because this is such a strange situation, because clearly they tried to fix the Johnson versus Abdullah problem. And if we were to agree with you, Dr. Wilkie could testify. It just seems almost absurd, in a sense, that we would reverse the trial based on this, and then he could go ahead and testify in a new trial. Don't you think?
Well, again, Your Honor, one of the things I would point out is today and post-rule change, we actually have additional reasons to challenge Dr. Wilkie's testimony. And so it would actually be an injustice to defendants to not have the opportunity to challenge what was at the time an unqualified witness based on the things that we have learned. So,
But again, those things are not on our record, that we are allowed to consider what the trial court considered. And
well, the trial court didn't consider the rule amendment.
I understand that. I'm saying as far as what the facts are. We can't consider those additional issues that have arisen between the end of the trial itself to now,
So,
unless it was actually on the record.
Your Honor, I would say you could not disqualify Dr. Wilkie on the basis of new facts that maybe were not in the record, in the trial record below. That much is true. You can take notice of the fact that there is, in fact, today, litigation pending by Dr. Wilkie against plaintiff's counsel relating to his expert testimony in the Durrani-related cases, and at least grant that defendants would have the right to challenge him. You do not have to make a call on whether that challenge would or should be successful, only that if plaintiffs get the benefit of something that happened after the record was closed and after the trial was complete, so too do defendants.
Can you help me with the timeline? Had the Supreme Court case of Johnson come out at the time that you were challenging Wilkie's testimony?
Your Honor, if I remember
Or even
right,
our case?
Johnson was 2021.
Yeah.
And this case went to trial in March of 22.
Okay, so
Johnson was
it
on-
had already come out.
Correct, Your Honor.
And so you focus solely on the fact that, hey, Supreme Court says he's not qualified, and you didn't raise any of these other potential issues because you thought you had it under the Johnson case, basically.
Well, Your Honor, yes, we thought we had it under the Johnson case,
Yeah.
and we did.
Right.
The sort of follow-on issues were litigation that developed after the trial in this case was over. So it's not that we sort of had information that we hid and sandbagged the court.
No,
We
no.
didn't have it.
Okay, I gotcha.
The other additional information did not exist until
Correct.
after the trial.
Correct, Your Honor. We did
Okay.
not learn about the nature of Dr. Wilkie's a fee arrangement with the plaintiff's law firm until after this trial was over, and it came out sort of in the form of Dr. Wilkie's allegations in his complaint. That case has not been resolved, but like the allegation and his side of the story are there, and we certainly would have used that if it had been available at the time.
But it wasn't available at the time, and you're asking now to be able to use a fact that didn't exist at the time of trial in a retrial. Is that what you're suggesting?
The underlying fact that Dr. Wilkie was testifying under a particular fee arrangement, that was a fact that existed. It's one we weren't aware of. All I'm asking is that if the court is going to apply a post-trial rule change that will work to the benefit of the plaintiffs to sort of cure testimony that at the time it was given was impermissible, we ask that defendants be given a retrial and the opportunity to challenge that expert witness
So-
on the basis of information we learned post-trial.
But do you see any distinction between a rule change and a fact that came into existence after the trial?
Not in this sense, Your Honor, that at this point it would be both parties asking you to evaluate the trial record on the basis of things that happened later that neither side would have been able to account for and fight about at trial. And all that I am asking here is if we are going to apply post-trial changes, both sides should have the right to make their case on that point.
And I guess my point is, do you see a distinction between a post-trial rule change and a post-trial factual occurrence?
If it had been a post-trial factual occurrence, Your Honor, I think we would have a problem. You wouldn't disqualify Dr. Wilkie on the basis of something he did or that occurred after trial. Our argument here actually would be the additional thing that would disqualify Dr. Wilkie is actually the fee arrangement he was testifying under at trial. What's changed is that now we know about it. But that fact, the occurrence, the fee arrangement itself, that occurred prior to trial. So it's not really a change in facts so much as a change in knowledge. It would be akin to the way we treat a statute of limitations, that, a statute of limitations can be delayed by not being aware of the injury. Which is not to say that you get the benefit of something that has happened later. It's simply you get to make an argument based on the knowledge you have when you get it.
I was going to ask, all of these cases are different, who testified and facts and everything. This particular case, in addition to Dr. Wilkie, there were two other doctors that testified for the plaintiffs, right?
Yes.
And those doctors, between the two of them, covered the main issues that they were arguing. Number one, that the surgery was not indicated and that the informed consent was wrong, right? So in addition to Dr. Wilkie, he's not the only doctor that testified to this stuff, right? They had other doctors.
He's not. But I would point you to
I'm asking about prejudice here.
So I would point you to pages roughly 17 through 20 of the trial transcript.
Okay.
When trial counsel moved to disqualify Dr. Wilkie. On page 19, trial counsel says, in addition to the Rule 601 argument, also point out, Dr. Bloomfield is sufficient on these issues. Any testimony from Dr. Wilkie would just be cumulative. The trial court said, I'm not in the business of admitting cumulative testimony, but I'm going to go ahead and let him testify. And so, trial counsel pointed out you didn't need to have Dr. Wilkie testify. The trial court disagreed. The trial court says it's not cumulative. I think it would be a pretty harsh outcome for defendants here for this court to say, actually, Dr. Wilkie didn't need to testify. His testimony wasn't necessary. And I think on the prejudice front for Ms. Ravenscraft, recall, Dr. Wilkie is only testifying about Ms. Bowling. Dr. Wilkie's testimony, it takes 167 pages of the transcript. It's the single longest block of testimony anywhere in this transcript. And it is only as to Ms. Bowling. It's a full day spent only on her. Imagine, and I know it's hard to imagine, a medical malpractice action with a single plaintiff. If plaintiff's counsel brings in an expert and says, a year before this case, the defendant doctor was sued for malpractice, can you walk me through why you think he committed malpractice in that other unrelated case? You would have no hesitation about vacating and reversing. or sorry, vacating and remanding for a new trial. And that's what we would ask for in Ravenscraft, is you have an expert who spends a full day testifying in unadulterated 404B other acts evidence, at least with respect to Ms. Ravenscraft. The word joinder doesn't work a magic on the jury that would allow them to sort of filter out what I think everyone agrees is irrelevant evidence as to Ms. Ravenscraft when they go back to deliberate her case. In fact, the point of joinder is to put together cases we think the jury ought to be weighing together. And so it'd actually be backwards to say, I know we put these together because we think the jury should treat them the same, but actually we're very confident that the jury managed to filter them out and separate them, especially when, again, you have a full day of testimony that is simply not at all relevant to Ms. Ravenscraft's case. So I think prejudice is almost inarguable, at least as to Ms. Ravenscraft. And with the trial court having told you and told defense counsel Dr. Wilkie was important to Ms. Bowling's case, if he's unqualified as to Ms. Bowling, that's a judgment that has to be vacated as well.
Okay. You are at your time. I was going to give you a little extra if you wanted to wrap up, and I'll give the other side a little extra time.
Your Honor, I think the remaining issues we cover pretty thoroughly in our brief, so I will sit down and I'll see you at rebuttal.
All right, thank you. Mr. Statman.
Morning.
Morning.
Deja vu all over again. I'd like to welcome my suit back to the courtroom. I've lost 50 pounds and I haven't worn it in a decade.
Very nice. Congrats.
Big day for me. This whole Dr. Wilkie lawsuit thing is not part of the record. There's some allegations going back and forth, but what counsel didn't tell you, and you have heard me express this before, is the difficulty with appellate counsel that didn't attend the body of the trials. This issue was raised and dispensed with all the way back when Judge Schweikert was here. The defense made all kinds of allegations about how Dr. Wilkie was going to be paid in all these
Well, I think
cases.
that's not part of the record, right?
Right, but
Yeah,
if
and
you're
I
telling
think
me it's out, I won't.
we can't consider that. I mean, I think
That's fine, I
our,
won't.
where we're stuck, where we're having issues, and you can help us with this, is the Johnson v. Abdullah case.
Well, if you remember, COVID was the reason these trials got halted. COVID took Dr. Wilkie out of his job because the hospital that he was working in closed. And it wasn't like he could go to a different hospital in some other city or state because elective surgeries were prohibited.
And look, I think it seems like a really good excuse, but the case of Selmer, which I think is what you're getting at and what the judge used as an exception, was limited to its facts, right?
Well, I don't think that Selmer is the only thing to look at or that it is 100% of the reliance.
Okay.
I think if you look at, as we discussed in my previous appearance a few weeks ago, the issue of a lot of special circumstances came into the legal business during COVID.
But we would have to create this COVID exception that doesn't exist, right?
Well,
What do we rely on for that?
I think that you have a right to look at that as an equitable issue when there is a pandemic, the likes of which hadn't been seen since 1918. You can't look at everything that occurs in a trial in an absolute vacuum. The Supreme Court suspended statutes of limitations and made all kinds of rules about trials can't go forward, courtrooms are closed. Those exigent circumstances that prevented us from using the expert should not now be able to use a rule created or a case created by the Supreme Court where a historical pandemic was not going on.
But
So-
didn't Johnson come out after the beginning? It was well into the pandemic, correct?
I don't recall
It's
the exact.
2021.
Yeah.
And then our case came
Well,
out before, during the
But,
pandemic.
but the argument in that case, when it got to the Supreme Court, was from years before the pandemic. A Supreme Court decision in '21.
I understand that. but-
Right, and so they were looking at a record that existed before the pandemic and had nothing to do.
Regardless, the court did say that Selmer was only to be limited, was to be limited to only those facts in that case. It didn't give room for considering other issues. It was limited to the facts in that case.
I don't think that when something occurs like what occurred, that you can then use that as a sword to strike down Dr. Wilkie by saying, this is it. He either fits the rule or doesn't fit the rule, even though he doesn't fit the rule now because an epidemic, a pandemic has occurred, the likes of which we haven't seen since 1918.
But hasn't that rule been interpreted in that manner for a while, where oftentimes plaintiffs' counsel were losing their experts because the expert wasn't
I
qualified?
don't have an issue with the general rule that existed before the rule was changed, and this case is still pending, as you pointed out.
Yeah.
So the new rule would apply to this case anyway, and this is at some level academic from the rule point of view. But I have no problem with, in 2015, you were either qualified or you weren't under the rule.
Okay.
But things happen that are completely out of control of everyone. The plaintiff
Doesn't that
control.
happen all the time with experts, where you have an expert and then all of a sudden they take a new job and then they can't testify?
Then you get a new expert.
But you also had two other experts.
Right, but getting a new expert wasn't something that was needed to jump back into the trial that was scheduled. The trial was taken off the docket because of a pandemic, not because our expert was no longer qualified. So if 6 months before I'm going to a trial, my expert decides to retire and move away to Indonesia, I have avenues for relief.
But
One
you
of-
knew at the time of the trial that your expert wasn't qualified under the rule, right?
No, at the time of the trial that would have taken place.
No, the trial that did take place.
Yes, but
knew
the
then.
judge had ruled that
He already said he could come in.
he had ruled in a number of matters. We already knew that he had created the rule that he created that brings us here, that Wilkie would be allowed to testify.
Created the rule that he created? What do you
Well,
mean? The
He-
COVID rule?
He created the exception.
The
you know-
COVID exception?
Is the law of the trial case by saying, one, COVID stopped the trial. Two, there was this upcoming change that was clearly on the horizon, and he allowed Wilkie to testify because he was qualified prior to the court shutting down for COVID.
But didn't you think you were taking a risk by putting Wilkie on, especially in light of the fact that you had two other doctors that would have been able to testify and give you what you needed?
No, because I believed when a pandemic occurs, and nothing like it has happened since 1918, it's not something that would not end up being a judicial exception to the rule.
So you
because
presumed that it would be a judicial exception?
Well, and we knew that the rule was going to be changing, and we understood that if the case was pending, well, then he's going to fall into that rule, the new rule. And here we are, and that's the exact circumstance.
You mean on appeal? Because at the time you tried the case, the new rule wasn't there.
It was not there, but
Okay.
if it was created, the case would still be pending all the way through appeal.
Right.
And they
So
have
you
appealed
believe because-
every case to all the way to the Supreme
you.
Court. So I could have weighed things the way you're saying, but the weight of it balanced out in my favor because once the rule was passed and it was imminent from what everyone believed, this case was going to be pending for a long, long time.
Okay.
As we see today, it's still pending, and it's 2025.
So you were looking at Rule 1102.
Yes.
Okay, and you
So-
said, you just thought, okay, if that rule passes while this case is on appeal, then the new.
And there seemed to be no question that it was going to move forward in the direction that it ultimately did. There wasn't a vocal opposition that was, making it an iffy question as to whether this was going to happen or not. But the fact is, there was other testimony. So Dr. Wilkie's testimony, if it's out, isn't prejudicial because the other doctors were saying he was negligent anyway. And we can go a step further. These were tried together, but the jury instructions and the interrogatories attached to them completely separated out the cases. And the jury had to describe in detail what the negligent acts of Dr. Durrani were.
Counsel, do you think it's realistic that the jury would be able to separate Dr. Wilkie's testimony with respect to bowling in the consideration of Ravenscraft's case? In other words, counsel has expressed a concern that Dr. Wilkie was allowed to, or testified for, I think, a day. With that kind of extensive testimony, wouldn't it necessarily pollute the case against Ravenscraft, or the case that Ravenscraft brought?
Absolutely not, and I'll tell you why. The juries, I've tried 124 or 125 of these cases. The juries have kept every detail separate. They have separate notebooks for each plaintiff. They keep detailed notes through the trial. The interrogatories require them to take each step through 11 to 14 different interrogatories to come to their determination in each of the cases. It is not unusual in the 124 cases I've participated in to have an expert testify all day, whether they're testifying in 1, 2, or 3 cases. That's not unusual. That's not even unusual in a single medical malpractice case. So this idea that the record was polluted because Dr. Durrani's testimony went all day is a completely specious argument. They were part of the cause of Dr. Durrani's extended testimony.
I'm sorry, I'm referring to Dr. Wilkie, the expert.
I mean, Dr. Wilkie's testimony, because Dr. Durrani's lawyer spent all kinds of time on cross-examination with him. So it's not just what he was saying about the plaintiff on direct. They elicited all kinds of testimony that they believed was favorable to them. And they believe that not a single Durrani case has any value. And you can look at the history of the verdicts and the prejudgment interest verdicts. There are some prejudgment interest verdicts. There are a few that there are no prejudgment interest verdicts. They have not offered a dollar, not $1 on 124 trials, not a dollar prior to trial, not a dollar. And they haven't made an individual offer after that because they believe that these are slam dunk winners for Dr. Durrani, and they continue to believe that. You all have reversed, I believe, about 9 cases on some evidentiary issues. We have retried those without the evidentiary issues that were excluded, and we have won 8 of the 9. So I think the juries are doing a pretty good job sorting this out. And the judge asked them about that at the end of every trial. Again, this isn't in the record, but Judge Reese stands up in front of him and says, did you have trouble sorting this out? Were you able to keep everything separate? And you know, he's doing that to see if he has to tweak anything as it goes forward. But these cases were clearly appropriately consolidated, and it is not that difficult, even though we may stumble as attorneys doing examinations over words where we might accidentally say Ravenscraft, not bowling. It gets corrected immediately, but it's not something that's pervasive through the whole trial, which is something they've brought up in their brief. And if you look at the consolidation issue, they're both L5, S1 surgeries. The experts are the same. The evidence is the same, the background on the
How
spine
can the
is the same.
evidence be the same, though? Because these are two different people, two different bodies, two different outcomes to a degree. I'm struggling to see how the evidence, I don't understand how it's the same.
Let me take you through that. So Dr. Durrani has a conference with the patients.
I understand that. I've read the transcripts, I understand all of that. But I'm talking about the actual treatment of the person.
Okay.
And let me continue. And whether surgery was necessary, that question, whether surgery is necessary for a patient, is necessarily going to depend on that person's individual body, that person's individual needs, that person's individual projected outcomes.
Not in Dr. Durrani's world. And the evidence is right in the record, and I'll point you right to it. Dr. Durrani writes a letter to the primary care physician in every case. And he outlines, patient by patient, why he has chosen to do this surgery. And he starts off typically with spondylolisthesis. Then he repeats that slippage of the bone, and he calls it anteriolisthesis. And in almost every case, their own experts have had to point out it's a retrolisthesis, that Dr. Durrani doesn't understand something going forward or something going backwards. Every case. Additionally, he says that they have severe claudication. Every case says severe claudication, neurogenic claudication. It is a disease associated with people typically far in excess of 70 years old. It's where you see people walking bent over, holding onto their carts, and it's right in the record, because that reopens the central canal and gives them some relief from the stenosis that is causing them
You're saying
difficulty
this is a
walking.
letter he writes to the primary care?
I'm sorry?
You're saying this is a letter that Dr. Durrani writes
Writes to the
So
primary-
in this case, with both of these plaintiffs, they both had the identical letter, is what you're saying?
Identical letters, both found to be L5S1 problems that required a fusion surgery, and all usually at 7 points. People who are working, he finds, are severely disabled from activities of daily life. It's in every single letter. They don't vary. And so when you say, how could it be the same? Well, maybe if we were at Mayfield Brain and Spine, it wouldn't be. But in Dr. Durrani's world, everyone had the same list of problems.
Just because your argument in all of these cases is not that the surgery went bad, it's that there shouldn't have been a surgery
There was
at all. There was-
unnecessary
Yeah.
surgery. And that leads to the fact, another fact, everything's the same in the sense that he exaggerates everybody's imaging studies. Now, he may call one severe and one very severe, but it's still a fact that it's an exaggerated imaging study from our experts' testimony and from the jury's findings 82% of the time in the cases that I've tried.
Would you think, though, in a situation where the argument was that the surgery went wrong or was improper versus there should have never been a surgery, in one of those kind of cases, would joinder be proper? Because I'm trying to understand, it sounds like you're saying joinder's proper here because he basically created this fake letter and lied about images, and that's why joinder's
Well,
proper.
I'm not only saying that.
It's not like he made a mistake during surgery.
Let's go back to your eye doctor case that you all decided. And right now, the name's escaping me, where 7 cases were tried together. That wasn't about fake this or that. Those were about 7 surgeries that were performed on patients, the same surgery with the same doctor, the same experts. So it's not about fakeness one way or another. It just happens that the similarities in these cases are that these were medically unnecessary surgeries.
So it's really about the fact that it's the same surgery, that you can group these trials together?
Well, no, there's a number of reasons you can group them together. It's not only the same surgery, it's the same issues with degenerative disc disease, claims of spinal stenosis and foraminal stenosis. It's not the one singular thing. It's the accumulation of the same experts, judicial economy, and on when you go through it. And if these cases are not consolidatable, then somebody ought to, at the Supreme Court level, say medical malpractice cases just should never be consolidated. It's an exception to the rule, and we need to put a letter D or E or whatever the last letter is in the rule that says no to medical malpractice cases. They haven't done that. So a medical malpractice case is capable of being consolidated. We have had in these cases operative.
I gave you extra time. You have about a minute left.
Okay, well, I think that the other issues we have addressed, the jury instruction issue and the fact that there was a secondary instruction that defined what inferences were, and that the judge actually made a ruling in these cases that any error that he may have committed was harmless error. So I think their burden is even a little bit higher because he went to the extent of examining that in retrospect to see if he thought he had made an error and did not. We think the case deserves to be affirmed that any error would be harmless based on the circumstances and the examination of the entire record. Unfortunately, these are somewhat record intensive. And so that's why you all have come to different conclusions occasionally on the same error. They say it was an error to do X. You agreed in one case, you disagreed in a different case because of the look at the record. So I would ask that you look at that record. I think that you'll see that this is appropriate and should be affirmed. Thank you.
Thank you. Mr. Williams. You have 3 minutes.
Thank you, Your Honors. I should have reserved more time. I, too, would encourage you to look at the record, where you will find almost nothing that you heard from my colleague over the last 15 or so minutes.
There's no letter?
So, Your Honor, you might locate a letter.
Okay.
No,
What are we not going to find?
Well, you just had a 5-minute colloquy on the Rule 42 analysis and finding a common question of law or fact that you will find nowhere in the record of this case or any of the other Durrani cases, because as this court observed in its mandamus order more than 2 years ago, the trial judge never made the Rule 42 findings. You did hear from my colleague that, you have judicial economy and the use of the same experts, which is a really curious point to make in this case, where Dr. Wilkie testified for one and not both of the plaintiffs. So in this case, to jump off something that Judge Bach had pointed out, you don't actually have the same evidence or the same experts in this case, but in fact, about 20% of the trial testimony in this case only related to one plaintiff. You also heard repeatedly that this was a case, the trial date got moved due to COVID. You will not find that in the record. You will find 2 trial dates in the record. You will find the 2017 trial date under Judge Ruhlman that got vacated during a number of the sort of the prior version of the consolidated trial litigation. And then you will find the trial calendar and the group trial order in September of 2020, which is about 6 months into the pandemic. The trial date gets scheduled for the first time during the pandemic. It's not moved because of the pandemic. You also heard from opposing counsel that somehow they anticipated the amendment to Rule 601 and were sort of holding the case and keeping their expert in view of that forthcoming rule. You will not find that in the record. You will not find that in their arguments. You will not find that in the briefs. And frankly, that degree of foresight, when you think about the time between trial and this rule being promulgated, that's a surprising and very risky amount of foresight. I see from the clicking that my rebuttal time may be expired.
You're getting close. You're on yellow.
I would conclude with Abdullah, as you pointed out, Judge Grouse, says to apply Rule 601 as written. The reason why the Selmer exception was limited to its facts was not just the court thinking there are no other reasons why we might delay cases. It was that to extend Selmer, and frankly, Selmer itself, is to rewrite Rule 601, which the court was not willing to do and directed courts not to do. So here you have an unqualified expert as to one plaintiff who is testifying in irrelevant, prejudicial other acts evidence as to the other. Neither of these verdicts could stand, and the case judgment should be vacated and remanded for new trials. Thank you, Your Honors.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case is now submitted. We'll issue a timely decision. Have a good rest of your day. All rise. Court of Appeals, first